Good morning, everyone. Thank you so much for joining the Surrey Board of Trade. I am Rona Doria, the Sponsorship Coordinator of Surrey Board of Trade. I want to welcome you to today's Digital Impact Learning Lab, Accessing Global Talent. I wanted to remind you that if you have any questions during this session, please put your questions or comments in the chat function and we will get back to them as soon as we can. If we are unable to answer your questions, we will get back to you after the session is over. I acknowledge that we are in the territory of Coast Salish people, specifically the Kwantlen, Katsi, Kwikwetlem, Kakite, Semiahmoo, and the Tuasan First Nations. As well, I acknowledge the Inuit and Métis Nations peoples who live and work on these territories. The Surrey Board of Trade is Surrey City Building Business Organization, where we support business and bring business into the city. We are here to advocate for you, to instigate change at different levels of government, and to be your concierge of connection. Check our diversified portfolio at businessinsurrey.com. I am pleased to introduce to you our facilitator this morning from Immigration, Refugees, and Citizenship Canada in BC, Outreach Officer Janet Fan. Janet, over to you.
Hi, everybody. Thank you very much, Rona, for the introduction. So as Rona mentioned, my name is Janet Fan. I'm an outreach officer with Immigration, Refugee, and Citizenship Canada. As you may know, IRCC is the federal government department responsible for immigration. So this means the issuance of work permits, granting of permanent residence, and eventually citizenship. However, my role as an outreach officer is to help Canadian employers such as yourselves learn how Canada's economic immigration program can be used to access global talent and help drive economic growth. So a very big thank you to the Surrey Board of Trade for inviting me to today's event. Now, before we continue, I would like to advise you that the information that I provide today is as relevant as of today's date, as policies do change. So please refer to our website for the most up-to-date information. And in the presentation today, there are many hyperlinks to the various pages of our website. Next page, please. So we know that employers and businesses are actively looking to fill hundreds of thousands of vacant positions in all sectors across Canada. And a recent report actually indicates that the immigration accounts for almost 100% of Canadian labor force growth. In 2021, Canada welcomed a record number of permanent residents of more than 405,000 individuals. And actually, we broke that record again in 2022 with more than 435,000 individuals. Now, of those individuals, almost 60% came through an economic immigration program, and 47% transitioned from a temporary program to a permanent resident status under various pathways, which goes to show that immigration is one piece of the puzzle to help employers attract and retain global talent. Next slide, please. So my goal today is to provide you with a basic overview, but the most important thing I would like you to take away is that IRCC provides services to help employers navigate the immigration program. At the end of this presentation, I will share with you our contact information so you can reach out to us when you need to. Here's a snapshot of the topics we will cover today. So key concepts that you will need to know in order to understand how Canada's immigration system works, an overview of the work permit program, and then the permanent resident program, and then last but not least, finding global talent. Next slide, please. So let's start with key concepts. What is work? Your definition of work may be a little different from what IRCC defined as work. IRCC defines work as per the Immigration Refugee Protection Regulations as an activity which wages are paid or commission is earned, or that competes directly with activities of Canadian citizens or permanent residents in the Canadian labor market. For the majority of foreign workers to work in Canada, they must have a work permit unless they're exempt. Next slide, please. So when it comes to immigration status, there are normally two ways that a foreign national can come to Canada. First, they can come on a temporary basis, whether to study, to work, to visit. And then the other way is they become a permanent resident as soon as they arrive in Canada. Now, in some cases, foreign nationals may happily maintain temporary residence for an extended period of time, as permanent residence may not be their end goal. And now for others, they may pursue permanent residence and eventually citizenship. Permanent residents can obtain their citizenship in as little as 3 years from the date that they become a permanent resident. Now, depending on the need of the employer and the desire of the employee, foreign national immigration paths may differ depending on their situation. And for this reason, it is good to have this conversation up front with your candidate so that you're both on the same page. Now, 2 key points to remember here is that first, there are various immigration paths for individuals, and secondly, that they must have valid temporary resident status until they become a permanent resident or they depart Canada. Next slide, please. So then the next question would be, well, how can I hire a foreign worker? Now, if the need is temporary or immediate, you may be supporting your candidate to apply for a work permit. And if the need is permanent, then you can support them to apply for permanent residence. And depending on your conversation with your employee, you may be supporting one or both of their application. Next slide, please. Now, before we talk about work permits, I want to make sure that you're all familiar with the key resources that we use in immigration. The National Occupation Classification, or the NOC, is Canada's national system for describing occupations. Think of it as a big dictionary of all occupations in Canada. Now, the NOC is updated every 5 years. So if you're familiar with this resource, you will notice some changes. The 2021 version introduced a new 5-digit structure as opposed to the 4-digit structure in the previous versions with the introduction of tier. Now, the tier category indicates a level of training, education, experience, and responsibility, TEER, generally accepted to that occupation by the sector, by the industry. So the tier skill level is divided into 6 categories, 0 to 5. The tier category 0 is for senior management, and categories 1 to 5 are based on the level of education or training required, with 1 being university degree and 5 being no formal training or on-the-job training. Now, what's important to remember for today's discussion is that if you want to hire a foreign worker, you will need to know the NOC and tier code of that occupation before you can make a job offer. And most of the exemptions under the International Mobility Program, which I'll mention in a bit, falls under the tier 0, 1, 2, or 3 categories, formerly known as NOC 0, A, and B, which are in the yellow box, and which are what we consider high-skilled position. The NOC and tier will define which LMIA exemption the applicant may or may not be eligible for. And I have here hyperlinked our online tool, Find Your NOC, which is on this slide. Next slide, please. So you may have heard me mention LMIA. So what is it? It's a labor market impact assessment, which is a document from that's issued by Employment and Social Development Canada, another federal government department, that gives employers permission to hire foreign nationals or temporary foreign workers. Now, Employment and Social Development will assess the employer's LMIA application to determine what's the impact of hiring that foreign worker into the Canadian job market. And if Employment and Social Development Canada issues you a positive LMIA letter, the employer will then give that letter to the applicant to support their work permit application. Now, the LMIA is usually given for a specific period of time, and the work permit is issued to match that period. So if the foreign worker wants to renew their work permit or wants to extend or stay, then they will likely need a new LMIA. Next slide, please. So now we're going to be entering into the topic of work permits. So first and foremost, we want to know, well, does the foreign worker need a work permit? And if they are entering into the Canadian labor market and they're working for more than 30 days, then yes, they will need a work permit. While there are some exceptions for global talent to enter Canada without a work permit, so under the global skills strategies, workers in tier 0 and 1 professions, so managerial or individuals needing a university degree, may enter Canada without a work permit for short-term work of up to 30 consecutive days per calendar year. But otherwise, everybody else will need a work permit. Next slide, please. So once it is determined that the individual will need a work permit, then the next question is, well, which work permit program? There are two different pathways. One is the Temporary Foreign Worker Program, and the other is the International Mobility Program. And depending on the position and how many individuals you're hiring, you may be using a combination of one or both programs to fill your hiring needs. Now, the Temporary Foreign Worker Program can be considered a measure to fill temporary skill and labor shortages in Canada. In this program, employers must obtain a labor market impact assessment to hire a foreign worker. The LMIA verifies that there is a need for the temporary worker and that there are no Canadians or permanent residents available to do this job. The second way is through the International Mobility Program, and this program supports talent attraction and economic growth and does not require the employer to obtain an LMIA before hiring a foreign worker. These LMIA exempt work permit exist because the work that falls under this program brings social, cultural, and economic benefits to Canada. Next slide, please. So here's a quick summary of the steps and costs associated with the Temporary Foreign Worker Program. The employer is responsible to apply for the LMIA with Employment and Social Development Canada and pay the $1,000 LMIA fee for each foreign worker that they wish to hire. Now, the worker is responsible for the work permit of $155 and the biometrics fees of $85 for a total of $1,240 fully, right? It is highly recommended that as an employer, you allow as much lead time as possible to apply for an LMIA so that there's sufficient time to assess the LMIA application, as this may take up to 60 days, and also allow time to have the work permit processed. Now, in BC in particular, employers are required to apply for the BC Certificate of Registration with the province of BC to enable them to hire a foreign worker prior to submitting the LMIA application. This is a requirement as of December 2020 to protect workers' rights in BC. So we recommend to employers to apply for the certificate regardless of whether you intend to or not hire foreign workers under the Temporary Foreign Worker Program, as this service is free and would save you time and headache later if you decide to apply or if you find an individual that you need to hire under the Temporary Foreign Worker Program. And I've included the hyperlink to the BC Certificate of Registration on this slide. Next, please. So the International Mobility Program, which supports talent attraction and economic growth, does not require the LMIA. So under this program, for an employer-specific work permit, employers need to use the employer portal to submit the offer of employment information and pay the $230 employer compliance fee. Then this auto-generated number then the system will provide you an automated generated number, the offer of employment number that starts with the letter A and follows by 6 digits. You will then give this number to the employees to support their work permit application. Now, to recap, before a worker can apply for an employer-specific work permit, the foreign national must have one of two things, either a positive LMIA letter or the offer of employment number from the employer portal. Now, if you do find individuals who are eligible for an open work permit, then as an employer, you do not need to follow either of these steps. You can hire them as you would any Canadian or permanent residents in Canada. Examples of individuals who have open work permits would be Ukrainian nationals, people from Iran, and people from Hong Kong. Now, next slide, please. So there's a variety of LMIA exemptions. Actually, there's more than 60. And as you see, the LMIA exemption can help employers save time and fees when hiring a skilled foreign worker. Now, how do you know if you can use an exemption? We have a complete list of the exemptions on our IRCC website. However, if you're still not sure, IRCC offers a free service called the International Mobility Worker Unit, which can provide you an opinion of whether or not the employer and the foreign worker you want to hire are exempt from getting an LMIA or the work permit requirement, which I've also included the link, the International Mobility Workers link. I would like to highlight several LMIA exemptions. So first and foremost, we have the Youth Exchange Program or the International Experience Class at Canada. otherwise known as the Working Holiday Program. So youth from the age of 18 to 35 from 30 different countries can come to Canada and they will also have an open work permit and can work with any Canadian employer. The provincial nominee or the provincial territorial agreement. So we have the provincial nominee program where foreign workers received a nomination from the province or territory of residence, and they will be able to get an LMIA exempt work permit and start working while they're waiting for their permanent residence application. International agreements. So Canada has many trade agreements with other countries and contain reciprocal talent mobility provisions. In these trade agreements, they set out in details the nationalities, the professions, and the qualifications of business people who can be granted temporary entry. And this includes technicians and professionals, contractual service providers, and intercompany transferees. Last but not least is the significant benefits. So employers can make a case of the significant economic, social, and cultural benefit to Canada for bringing in the foreign worker or new business can benefit from an LMIA exemption, such as francophone mobility, entrepreneurs, and intercompany transferees. Next slide, please. So we have a new exciting new measure in place for spouses and working age children. There is a temporary 2-year measure in place which allow family members of work permit holders in Canada to apply for a open work permit. Now, when we say family members, we're talking about immediate family members. So this is the spouse, the common law partner, and dependent children under the age of 22. The family member can apply for the open work permit at the same time as the individual applying for their own work permit. And the family open work permit is valid, will match the same validity date as a primary applicant's permit. So the open work permit under this program authorizes the family members to work legally in Canada. Next slide, please. So as I've mentioned, open work permit multiple times in this presentation. So again, what do I mean by that? Is an open work permit allows a holder to work for any employer in Canada, and they're only issued in very specific situations, such as I mentioned, family members, a working holiday program, the Ukrainians, HR public policy, and the employers benefit from this because they do not need to go through the process of applying for the LMIA or applying through the employer portal, and they don't need to pay those fees. Next slide, please. So one of the most important tools in your immigration toolkit is the global skills strategy. And I've mentioned this previously in a few slides up. And this strategy has the explicit objective of facilitating employers' access to highly skilled foreign workers in order to succeed in the global marketplace. Now, this strategy has 4 pillars. First and foremost, 3 of which belongs to IRCC and the 4th belongs to ESDC. Now, first and foremost, the first pillar is priority work permit processing for highly skilled workers that apply through the International Mobility Program at the Tier 0 and 1 level, or those who require an LMIA under the Global Talent Stream, which I'll mention in a bit. And the spouse and dependent children of these skilled workers also receive priority processing. The second pillar is the work permit exemption for short-term work, which enables managers and professionals, again, Tier 0 and 1, to work in Canada without a work permit of up to 30 days per calendar year. And this saves administrative work and is particularly valuable to get talent in quickly to launch new projects. The third pillar is to access the dedicated service channel, which gives companies making significant investments in Canada access to the expert guidance of an account manager. Companies must be referred to the service by referral partners. In BC, we have 17 referral partners to refer your companies to the dedicated service channel. And last but not least, the 4th pillar is the global talent stream for employers hiring under the temporary foreign worker program where the LMIA is needed. This is an expedited way to get a labor market impact assessment for in-demand and skilled positions that are on the global talent occupation list. Next slide, please. So as I mentioned, this is the global talent occupation list. There are a total of 24 professions that are listed On this list, there are primarily professions in tech and engineering. So computer engineer, database analyst, software engineers, civil engineers, etc. So for foreign workers in these professions that are listed in this global talent occupation list, they get priority processing for their LMIA, as well as priority processing for their work permit under the global skills strategy. Next slide, please. So now we're moving on to the permanent residence portion. So what is Express Entry? Express Entry is Canada's flagship system for managing applications for several of our key economic immigration programs. More than that, Express Entry is a portal through which people from around the world can express their interest in immigrating to Canada. Those who are most likely to succeed economically in Canada are invited to apply for permanent residence and benefit from faster processing using this online system. Now, the applicants can create an Express Entry profile, and those who appear to meet the criteria of one or more of the 3 federal immigration programs managed through Express Entry are then automatically entered into the Express Entry pool of candidates. Then the candidate are given a comprehensive ranking system score. The top ranking candidates are then invited to apply online for permanent residence. So what's important for you to know as an employer is that applicants who may get an additional 50 points for having a job offer in positions in the tier 1, 2, or 3 level, and up to 200 points if the position is in an executive level, tier 0 level. Additionally, applicants can get up to an additional 600 points by receiving a provincial or territorial nomination, which as an employer, you can also assist them with their provincial nomination by applying with the province. Now, on a recent round of invitation, just so that you know, on a recent round of invitation on April 26th, the minimum score is 483. So if you can assist them with the job offer or the provincial nomination, then it would increase their chance of getting invited to apply for permanent residence. Next slide, please. So the Express Entry manages the following federal economic immigration programs. So the Federal Skilled Worker Program, the Federal Skilled Trade Program, and the Canadian Experience Class. Now, each program has their own minimum criteria based on work experience, education level, and language proficiency. And all of these programs will require work experience in occupation tiers 0, 1, 2, and 3. The work experience gained abroad counts for the Federal Skilled Worker Program and the Federal Skilled Trade Program. However, for the Canadian Experience Class, the work experience must be gained in Canada. Next slide, please. So now we've gone to the Finding Global Talent section. So now that you have the immigration tools in your HR toolkit, you may be asking yourself, well, where do I find these foreign talent? Now, you can start by looking right here in Canada. There are already in Canada those who hold work authorization, including open work permits, which allows them to work with any employer in any job. Did you know that many international students are also eligible to work part-time off campus while they study? Some of them may also get a co-op work permit to complete internship. Their spouses and partners may be eligible for an open work permit. And after graduation, they may be eligible for an open work permit called the postgraduate work permit. So our universities, colleges, and technical institutions are a great place to look for international talent. You may also connect with newcomers in Canada through IRCC funded organizations such as the Immigration and Employment Council or any immigration settlement organizations in BC like Mosaic, ISSBC, etc., who have programs to help newcomers find employment. There are also many Entry Express candidates who have profiles on Canada's Job Bank website, and you can use the free job match service to connect with those who have skills and qualifications that you are looking for. On this job bank website, there's also a specific page for hiring Ukrainians in Canada, which I've included the hyperlink on this slide. Next slide, please. So just a little bit more about the international students. So again, hiring international students, they may work up to 20 hours a week while class is in session and full-time during scheduled breaks. So this is winter break, summer break, and reading break. So to qualify, the student must have a valid study permit, have begun their studies in an eligible program, be studying full-time at an eligible post-secondary institution, and have applied for their social insurance number. Now, from November 15th, 2022 until December 31st, 2023, internationals who are in Canada who have an off-campus work authorization on their study permit are not restricted by the 20 hours per week rule. And this is only if they have applied for or received their study permit on or before October 7th, 2022. So again, if the student has received or applied for their study permit on or before October 7th, 2022, they are allowed to work an unlimited number of hours between November 15, 2022 until December 31st, 2023. Otherwise, they're limited to that 20 hours per week rule. Next slide, please. So as mentioned, international graduates, once they've completed their study program, they may be eligible for a postgraduate work permit, which allows them to gain valuable work experience, Canadian work experience, so that they can qualify for permanent residence afterwards. So again, this work permit may be valid for up to 3 years, depending on the length of their study program. Last slide, please. So here are some resources for employers. So if you want to use the Temporary Foreign Worker Program, or you have questions about the LMIA program, Employment and Social Development Canada has an employer support center, contact center with their number, the 1-800 number in this slide. As mentioned, there is also the International Mobility Workers Unit to help you determine whether the individual is exempt from having a labor market impact assessment, and you may email them at this email address. And if you want to find out more about any of these immigration topics, there's a network of 14 outreach officers, just as myself, strategically located across Canada, who are here to help employers. So you may contact us at the promotion email address listed on this slide. Next step, please. So this has been a quick overview of our immigration programs in Canada. Our website can be easily accessed at canada.ca/immigration, and it contains a wealth of information about our immigration programs. You can also follow us, like us on Facebook, follow us on Twitter to find out the most up-to-date information. And next slide, please. That's it for my presentation today. Just to reiterate, I'm an outreach officer responsible for BC, and we're here to support employers to understand economic immigration programs that can be used to support hiring needs. So if you have any questions about your specific circumstances or situation, please feel free to contact us again at our email address, promotion@cic.gc.ca. And thank you very much for your attention today.
Thank you so much, Janet. We have one question here. How can one find out if their jobs are LMIA exempt, where they do not need LMIA but can still get 50 points for the job letter?
Okay, so that's two separate things. One, if they're LMIA exempt, there is our website. There's a page on our website which lists all 60 plus of the LMIA exemptions. And again, they could also contact the International Mobility Workers Unit to verify if the candidate that they want to hire are exempt from an LMIA. So in that, when you're submitting an opinion, you will need to submit like information about where the individual is coming from, what occupation they're working in, what's their position that you're hiring them for, and then they will find out, they will provide you with an opinion on whether or not they're exempt from an LMIA. Now, when you're talking about the 50 points, that's a separate issue for the permanent residence program. And so they can, if you provide them with a job offer with their application for permanent residence, then they will get that 50 points. And it's separate from whether they need an LMIA or not.
Okay, so Kapil, I hope that answers your question. We have another question here. Is the dual intent LMIA application process the same as the regular LMIA process, or is it different? Can you explain how the dual intent LMIA works for employers?
So when we talk about the dual intent LMIA, this is when an individual is already applying for permanent residence as well as needing a work permit while they're waiting for their permanent residence application. So the process is still the same. If you are applying for both, like a temporary, like a work permit, as well as the permanent residence, then it's the same process. It's still $1,000 for that LMIA. They still need a positive letter. They still need to apply for that work permit. Now, this is different if you are just providing them a job offer to support their permanent residence. Then in that case, they don't need, and the LMIA would be different because you won't need to pay for that $1,000 LMIA because they're only applying for permanent residence. But if it's dual intent, so they're applying for the permanent residence and for their work permit, then yes, they will be following the same steps.
Okay, so there's another question. I think this is related to the first question about the job letter. For Entry Express, does that mean a job offer given to a candidate but not having an LMIA can qualify for 50 points?
Yes, so if they're providing the LMIA for their if they're providing the job offer for their permanent residence application, then they do not need to pay for the LMIA the same way as you would apply for the work permit, which is $1,000. So they can apply, so they will get their points. So when they're applying for when they create their profile in the Express Entry, they will provide also that letter of their job offer letter, right? And then with that, they will get that 50 points to say that they have a job offer available for them when they become a permanent resident.
Okay, are the not-for-profits considered LMIA exempt?
Not that I'm aware of. There's a list of 60 plus LMIA exemptions on our website, and it really depends on the type of position that they're applying for, where they're coming from. It really depends. So you have to check on our website for that 60 plus LMIA exemptions.
Okay, so here's another question about the international student. If you can clarify regarding an international student who recently had a full-time job of 40 hours per week. This the new rule that allows them to work full-time job till December 31, 2023 affect the status of their employment?
Okay, well, we need to backtrack and maybe need more information about this, but for students, so they're normally only allowed to work 20 hours per week off campus, right? Now, if they have a study permit, if they applied for or received their study permit before or on October 7th, 2022, then they can work full-time between November 2022 and December 2023. So I'm not really sure what that question was asking about, if the student was already working full-time and then whether this public policy will affect it, because they should not be working full-time with just their study permit.
Oh, the person is working full-time. The person is working full-time, so she's asking if working 40 hours per week will affect their employment status, and the person is an international student.
Okay, well, because international students are only supposed to be working part-time, so up to 20 hours per week, so nothing more than that. This new public policy allows them to work full-time only if they meet those requirements. So if they've applied for or received their study permit on or before October 7th, 2022. Now, if they're working full-time as a student, that may affect their status as a student, and then later on affect their status to apply for their work permit later. So it depends. I mean, there needs to be more clarification of what's going on in this situation, but it seems like they shouldn't be working full time. I'm not really understanding this question.
Okay, so we will connect the participant to you for further, to clarify her question.
Yeah.
There is another question here. If a job offer is given for PR, but the employer is not having any LMIA at the time of giving a job offer, will this job offer still earn 50 points?
Well, so you need the LMIA to give them the job offer so that they actually have a job, right? Like, so just by giving them a job offer is not sufficient. You actually have to employ the individual so that they can actually apply for their work permit. So they will get 50 points if you actually provide them with that position, right? I'm not understanding this question either. So, okay, so the individual needs to have a valid job offer.
The person is in has open work permit. So
okay,
just to clarify, the person has open work permit.
Oh, okay, so if they have an open work permit, then yes, they don't need an LMIA. The employer can still give them a letter of offer to say, yes, we have a job available for them. And then, yes, they will be able to get that additional 50 points for their comprehensive ranking score.
Okay, so I hope that clarifies your question, UB. So are there any other questions, please? Okay, so I think that's about it. We don't have any more questions. And thank you, Janet.
Yeah, thank you very much, everybody.
Yeah, thank you, Janet, for being with us today and sharing this important information. We will be sending you the recording and the facilitator's contact information after this session. Many more of these type of sessions are coming up, so please be sure to check our website at businessinsurrey.com. Make it a great business day. You may leave the meeting.
Thank you very much. Have a nice day. Bye.